Hi everyone, we're going to go ahead and get started. It's my pleasure to introduce to you today our final speaker in our final Human Rights in Practice series for the year. And our speaker is Nusrat Choudhury, who is the Deputy Director of the Racial Justice Program at the ACLU. And her particular topic of focus will be how court-imposed debts punish people for being poor. So the topic is modern day debtors' prisons. And as I mentioned, this particular event is part of our Human Rights in Practice series, and that series is one that has been co-sponsored by the International Human Rights Clinic and by the Centre for International Comparative Law. And this particular event is also being co-sponsored by the Duke Human Rights Centre at the Franklin Humanities Institute, the Duke Human Rights Centre at the Keene Institute for Ethics, the Human Rights Law Society, and the International Law Society. So Ms. Choudhury is going to speak for about 20 minutes or so, and then we're going to open up the floor for a Q&A. And I encourage you in that Q&A to identify yourself, identify what year of law school you're at, if that's where you are, and then we can have a really productive and engaging back and forth in that Q&A. So please join me in welcoming Ms. Choudhury.
Let me grab some water. Yes. So it's a pleasure to be here. I've never actually been to Duke Law School, but one of my most treasured colleagues went to this school and graduated and started working with me on building exactly the work that I'm going to talk about today. So it's wonderful to be here. I'm with the National ACLU, the American Civil Liberties Union, which most of you may have heard of, but if you haven't, the ACLU is a nationwide organization. We are actually the world's largest public interest law firm. We also do public education and advocacy, in addition to the litigation that we're most known for, throughout the country through the National Office of the ACLU and 54 affiliates that are based in the state, including here in North Carolina. And we work on the full breadth of civil rights and civil liberties issues. That includes things like women's rights, which many of you may have heard of, based on the pop cultural icon that is Justice Ruth Bader Ginsburg, who founded the ACLU Women's Rights Project. We work on prisoners' rights, criminal law reform, death penalty work, reproductive freedom, racial justice, speech privacy and technology, and really all of the issues that touch people across the country when it comes to exercising their basic rights to human dignity, liberty, and equal opportunity in this country. My work at the Racial Justice Program and with my colleagues, we're a team of about 14 people, we focus on fighting white supremacy, racial bias, and the drivers of racial and ethnic inequality, which we see throughout this country is omnipresent, despite the gains, the really important gains that have been made in the past decades. And our mission is to dismantle those barriers to equality and show that every person in this country has access to the full benefits of equality, opportunity, hope, and living with dignity. And fighting modern-day debtors' prisons is critical to the work that we do. And so I'll take you a little bit into it through the story of one of our clients, Tawanda Mershinda Brown. She goes by the name Shinda. So Shinda, like many people for many years, was working low-wage jobs in the fast food industry. At the time, this was about 2015, 2016, she was working at Burger King, not far away from here in Columbia, South Carolina. And she is the mom of a number of children. One of her children was 13 years old. He was in middle school. Her other children had grown and left the home and started their own lives. But she was in touch with them as well and helping one of her kids as he was struggling to kind of get on his own 2 feet and was working. And on the job, he got really sick. He actually got into an accident and had to have surgery. Shinda's working at Burger King. Shinda takes a week off to help her son, and during that week she doesn't get paid. At the same time, her employer's paychecks start bouncing. So she's in this really precarious financial situation as a working mom, supporting her family. All of a sudden, more instability than normal. And at the same time, she gets a couple of traffic tickets. One of the tickets has to do with a headlight issue. Another ticket is for driving without a license because she never actually had a license, as many folks in low-income communities don't. She gets ticketed for those offenses. She goes to court. This is in the Irmo Magistrate Court right outside of Columbia, South Carolina. And she goes to court and she wants to make this right. She knows what she did was wrong. She stops driving without a license. She gets a ride to court. And she tells the judge, what should I do? I want to make this right. The judge says, you have to pay $2,400. For the driving without a license ticket, we're going to charge you with driving under a suspension. that fine is going to be more than $2,000. For the other ticket, it's going to be a couple $100. The combined total is $2,400. And can you pay in full today? And she said, absolutely not. I can't afford that at all. I could afford to pay something like around $100. I think if I struggle and I try to make ends meet, I can pay $100. The judge says, no, that's not good enough. I want you to pay $150 every month. You're going to have to pay a 3% collection fee on top of that. And Shinda said, well, Your Honor, I can't pay that. And the judge said, I want my money. I want my money on the 11th of every month. I don't care how many kids you have, and sent her on her way. So Shinda then is struggling, but even as she struggles, she makes 5 payments. Every month, around the date that it's due, she makes those payments. And then, while she's taking care of her son who's ill, when her employer at Burger King's paychecks are bouncing, she misses a payment. Weeks later, sheriff's deputies arrive at her home. It's a Saturday morning, and her son goes to the door and says, Mama, the sheriff is here. She gets up slowly, she goes to the door, and she's really worried, and she knows what's going to happen. And she tells her son, go take out the trash, because she didn't want to see her son watch her leave the house in handcuffs. Her son goes to take out the trash. She's arrested by the deputies and taken to jail and told, if you don't pay the full amount you owe, which is around $1,900 right now, you're going to jail. And she said, there's no way I can pay that. I don't have that in savings. I actually just started a new job. I was unemployed for months because my boss wasn't paying me at Burger King. I finally have this new job, and if I actually just get back to work on Monday, I'm going to become a permanent employee and actually be able to start repaying this debt. I really want to do that. And the jailer said, no, if you don't have the full amount, we're going to throw you in jail. She was in jail for 57 days. And during those 57 days, she turned 40. During those 57 days, she worried that her 13-year-old son was going to be taken by child welfare services because she was in jail. She was worried that her other children living in the apartment were going to lose their utilities. She was worried that she was going to lose the job that she had just gotten, and in fact, she did lose that job. So she comes out of jail 57 days later, poorer, more in debt, less stable, without a job, and the consequences on her life and her family are disastrous. This is happening to thousands of people across the country. And we at the ACLU have known this has been happening since at least 2009. We wrote a report in 2010 called In for a Penny, America's Modern-Day Debtors' Prisons, and it called the alarm on the rise of people being jailed, not for something that they did, but simply because they were too poor to pay money to courts. Courts that slowly, over the past 40 decades, have become revenue generators rather than places that are focused on administering justice and keeping us safe. And that's why we created a court system in the first place, to be a neutral arbiter of justice. But instead of seeing equal justice, what we see is devastation and a funnel that takes poor families, predominantly of color. These are Black and Latinx people, Native American people, mostly, funneled into this maze that they can't get out of unless they have the money to pay. But they would never be in that maze in the first place if they had the money to pay. So this is the rise of America's modern-day debtors' prisons. And I think the country started becoming aware in 2010 when we sounded the alarm and our report documented illegal incarceration of people simply because of their poverty in states as diverse as Washington, Ohio, Georgia, Louisiana. But I think the country became really aware after the killing of Michael Brown. Because what happened after Michael Brown was killed, which was a tragedy, was a Department of Justice civil rights investigation into why he was killed. And there was 2 parts of that investigation. One had to do with why was he killed? Did the officer use excessive force? What happened there? And then also, how are the police treating the people of Ferguson? And why did the community erupt in this huge way against the injustice of Mike Brown's killing? Why did this become a rallying call, kind of really just unearthing the significant distrust of the court system and the police amongst Ferguson's community of color? And what the Department of Justice found in their report, which is a really deep dive, into a court as a municipal revenue generator was that the entire city, from mayor to the court administrator to the police chief, knew that the purpose of issuing tickets, of serving tickets, of getting money towards those tickets was to raise money for the city. A significant portion of Ferguson's public revenue came from traffic tickets, and people were being jailed multiple times when they couldn't pay, including terrible stories, like a homeless woman whose $150 parking ticket ballooned into more than $1,000 of fines and multiple jail stays, and the use of jail to try to get people to pay money that they simply don't have, and people being squeezed. So after Ferguson and this Ferguson report came out, I think the country started waking up that our court systems have become revenue generators, totally trampling on the rights of human beings, people like Shinda Brown. And Shinda Brown isn't alone. We represent Shinda and 6 others in a class action lawsuit called Brown versus Lexington County, South Carolina. And that lawsuit is challenging the county's generation of revenue through the collection of court fines and fees from these county-level courts called magistrate courts. And there are multiple courts, there are about 8 courts. They raise millions of dollars every year, and they trample on long-standing constitutional rights. The most basic one is a 14th Amendment right to due process and equal protection of the law. And that right was actually articulated really clearly by the Supreme Court in a case called Bearden versus Georgia in 1983, where Danny Bearden, a man who was on probation, he was sentenced to jail time, he served his jail time, he was then on probation, and as a condition of his probation, he was supposed to pay a certain number of fines. And he missed a fine payment. And the court that wanted the fine payment automatically jailed him. And the U.S. Supreme Court said, in an opinion by Justice Sandra Day O'Connor, a unanimous opinion. This was not a controversial case. A unanimous Supreme Court opinion written by Justice O'Connor, who was not a radical liberal, that it defies fundamental fairness and equal protection of the law to punish people with jail simply because they don't have money. And what the court should have done before throwing Danny Bearden in jail is actually look into the reasons for his non-payment, to figure out whether he was able to pay and whether his failure to pay was, quote, willful. And if it was like willful, meaning intentional, he had the money and he chose not to pay it, yeah, a court could jail him. But otherwise, if it wasn't willful, the court should really be looking at alternatives to jail time. So that is the law. That's been the law for decades. But what we've seen in the last 30 years is this intense pressure to raise revenue from the legal system to pay both for the legal system itself as well as general public funds for cities like Ferguson, for counties like Lexington County. And they are not alone. This is happening throughout the country. We've brought lawsuits similar to Brown versus Lexington County, South Carolina. We've brought these lawsuits in Georgia, in Mississippi, in Washington. We have a lawsuit here in North Carolina itself, and I can tell you a little bit about that one. In addition to people being jailed, literally incarcerated because they don't have money, more than 40 states across the country will take away your driver's license if you don't have money to pay your court fines and fees. In North Carolina, this is a statute. Statute 20.24.1 mandates that the state will take away your license if you miss a traffic payment or fine and fee, regardless of the reason. And what that means is that hundreds of thousands of people have lost their licenses in the state of North Carolina, and we brought a lawsuit challenging this system, this automatic suspension of licenses without first giving people a chance to explain why they couldn't pay, so that the rule in the Bearden case is also applied to the driver's license suspension case. Because it doesn't really, when you think about it, it doesn't advance public safety, which could theoretically be the purpose of this kind of a system. When you take away someone's license because they didn't pay court fines and fees, the theory could be, well, we want to keep our streets safe. We want people to be punished when they violate traffic laws. And that's a seemingly legitimate idea, but it doesn't work when what you're doing is automatically taking away someone's license or automatically jailing someone because they couldn't pay. Because then you're not actually looking into the reason for the non-payment, and you're not giving them a chance to serve their debt to society in some other way. And there are lots of other ways to do this. Justice O'Connor in the Bearden case talked about them. She was like, you could give someone a payment plan. You could reduce the amount they owe to something they can pay so that they could pay it, and then they could get out. There are all sorts of alternatives. And there are some solutions. So I do want to talk a little bit about what some of the solutions look like, which is why these systems are so nonsensical and why they wreak such tremendous havoc. In the city of Biloxi, Mississippi, and I love that this was Biloxi, Mississippi, because most places in the country don't want to look like Biloxi, Mississippi. They think Biloxi is backward, Mississippi is the poorest state in the country. You know, why should we be learning what Biloxi did? Well, what we saw in Mississippi is we did a big investigation in 2015, and we saw that there were a number of debtors' prisons throughout the state of Mississippi. We saw a lot of cities that were jailing people because they couldn't pay fines and fees. And we brought a lawsuit against the city of Biloxi because the city of Biloxi is a relatively wealthy town. Those of you who might have been to the Gulf Coast, what does Biloxi have? Biloxi has casinos. Biloxi has revenue coming from other places, but what Biloxi was doing was jailing people who couldn't pay fines and fees to their municipal court. Fines and fees for things like a speeding ticket, for having a broken taillight, which also tend to be offenses that are disproportionately enforced in communities of color, right? So like that's where the tickets are being issued. That's where more people are likely to have equipment violations and crimes of poverty, I would say. But let's table that for a second. And that what we saw the municipal court doing was putting people on the supervision of a for-profit company called Judicial Correction Services. And what Judicial Correction Services said it was going to do was, hey, Biloxi, we're going to help you raise money through your court system. If people aren't paying, just put them on probation with us. Forget the fact that probation was actually traditionally devised as a way to kind of rehabilitate people who needed rehabilitating. But these are people who owe money. We get it. Just put them on our rolls, and we will collect money from them for you, and we'll also tack on some additional fees. So then you see these like debts like really piling up. And what we did was bring a lawsuit on behalf of 3 people who had been jailed for periods of time ranging from 2 days to 7 days to 10 days because they couldn't pay those multiplying fees to the probation company and to the city. But when we sued Biloxi in a class action lawsuit, what they did was pick up the phone and say, can we come up with a solution? We don't want to fight this case. We want to be a part of showing the world and Mississippi how to do this better, how to do this right. And so what we worked out with Biloxi over the course of 6 months was a detailed settlement agreement that created a public defender's office to represent anyone who was charged with not paying fines and fees or doing community service so that they have an advocate standing next to them to say, hey, judge, this person really can't pay. Let me help you, judge, make the right decision here so you have all the information in front of you to help protect this person's rights. They also got rid of for-profit probation. They cut out that company and they made a pledge we're not going to do that anymore. They also started looking at ability to pay and adopting a system so that judges don't have to do this on the fly by themselves. They created standards. Anyone who earns less than 125% of the federal poverty guideline, presumed indigent and unable to pay. Anyone who's homeless, presumed indigent, unable to pay. Anyone who was recently incarcerated, indigent, unable to pay. Anyone with a mental health condition, that means that they're residing in a mental health facility, indigent and unable to pay. And further guidelines. And we worked out with them things like checklists so that judges can make these decisions quickly and reasonably to solve this problem because they also got it. That it's not keeping their city safer, it's not helping them do their job to jail people simply because they don't have money. So there are solutions out there, and I think Biloxi has caught the attention of other jurisdictions that have been sued. Dallas was sued recently for jailing people who couldn't make bail. And a city official wrote an op-ed that said Dallas needs to take a page out of their book from Biloxi. And that was awesome. Because when cities do try to do the right thing, they should be celebrated. When cities don't do the right thing, when those models are out there, they should be sued. And they should know that they're going to be sued and that these lawsuits aren't going to stop. And what the lawsuits do is they force people to actually look at the accounting and look at the reasons and look at the impact in ways that have been ignored and invisible for years. The poor Black population of Biloxi, Mississippi, the poor Black population of DeKalb County, Georgia, the poor Black population of Lexington County, South Carolina. These are folks who've been suffering from these systems for years, and their cries have gone unheard. They've only been unearthed through these lawsuits that when we go into jail and we see 300 Black people in the DeKalb County jail because they couldn't pay fines and fees to a private probation company, due to traffic fines to the DeKalb County Recorder's Court. That's what the litigation does. It unearths their stories. It holds accountable people to the constitutional rights that we should all respect. And it also sends a message that we need to have more systemic change. So each of these lawsuits that we've brought has been combined with a state litigation strategy or a state strategy of getting court rules changed or guidance from the Supreme Court so that things change in other parts of the state. After we sued Lexington County, South Carolina, the Chief Justice of South Carolina issued a memo to all of the judges in the state saying, you are trampling on the right to counsel because I'm learning from these litigations filed by the ACLU that people are being jailed without being appointed a lawyer. I don't think that memo solved the problem. That's why our litigation is continuing. But what that memo did is it resulted in the recall of more than 10,000 arrest warrants from across the state of South Carolina. And what that means is there are thousands of people who would have been automatically jailed because they couldn't pay money to courts, who all of a sudden weren't because they're taking another look at the system. Now, coming up with the solution for the state of South Carolina is going to be more difficult, more detail-oriented. We're going to have to really get in there and figure out what's going on in the court system, because what we see even in the courts of the county that we sued is that even with ongoing litigation, judges are still not properly appointing people counsel. They are not assessing fines that people can pay, and they are not changing their practices. And part of it's because there's this culture that folks have become judges in. They have grown up in a culture where there are hundreds of courts in the state of South Carolina that don't have lawyers. These are lawyerless courts, courts where judges will send people to jail without anyone standing next to a human being who's facing jail time and can't afford their own lawyer. And we fundamentally should never live in a country that treats people's liberty that casually. Because what then happens are stories like Shinda Brown's. Shinda was in jail for 57 days. Another plaintiff in this case was in jail for 63 days. And I am talking about America. I am not talking about Iran. I am not talking about Bangladesh. I am talking about this country. I'm talking about our backyard. This is unconscionable. It is a racial injustice. And I think there are people who want to solve this. And what we need to do is keep suing around the country to keep the pressure on so that when there's legislation introduced, when there are court rule reforms that actually could be made, there are consequences that people know will follow if those changes don't get enacted. So this actually has resulted in legislation in the state of Georgia. After we sued DeKalb County, Georgia, on behalf of Kevin Thompson, a teenager who couldn't pay an $800 fine that was due in 30 days, in addition to fees to one of these probation companies, he became the face of this issue, and that led to legislative reform in Georgia, limiting what the for-profit probation companies could do, limiting the amount of money that they could collect from people to try to break that financial incentive to raise money through the courts. In Mississippi, after we sued Biloxi engaged in this really sweeping transformative settlement agreement, and the state legislature just last year, as a result of the public education, the information about this problem, how widespread it was, they passed a law throughout the state requiring some of those reforms to be implemented statewide in Mississippi. And we've also seen at the national level, the American Bar Association has taken notice of Biloxi and DeKalb County, Georgia, and our cases in Washington, and has issued 10 guidelines on court fines and fees, which are now set a professional standard across the country. And a number of those principles say things like people shouldn't be sentenced to fines they cannot pay. Courts should be funded by public revenue, not from the money they collect from the people in the system. Because when they do that, they're no longer neutral. People should have a lawyer. It also talks about what ability to pay standards could actually look like. So what we've seen since 2010 is actually really a tidal wave of litigation and reform from around the country, and I am hopeful that this is a battle that we can win. But it's a battle that's not going to be won without more lawsuits and more liability for more jurisdictions around the country.
Okay, so I have a lot of questions, but I'm going to open up to...
Yeah.
I'm going to open up to the floor. So again, just say your name and what year you are before you ask Ms. Choudhury your question. Yes.
Hi, I'm Zan. I'm a 1L. I'm wondering if you guys have looked into the financials of this in terms of, like, it strikes me that it has to be cheaper just to make these fines lower than put all this money into enforcing them and jailing people? Like, what is that? What are those numbers look like?
So that's a really good question. And I think part of the answer is complicated because municipal budgeting and county level budgeting is a mess. So before we file these lawsuits, we look really deeply into what is going on. What's the revenue in? What's the revenue out? And we're limited by the fact that we do our investigations using the Freedom of Information Act. We can't get all of the information they have. But what we see is that the people who pay for the jail aren't the same people who get the revenue in. So it's actually, there's no one in the government who sits down and looks at that and makes this rational decision of, oh my God, we're not getting as much money in as we're getting out, let's stop this. It's much less rational. What people see is the money coming in. They don't really factor in the jail. And sometimes this is because we sued in Benton County, Washington, in the Pacific Northwest. So, let's be clear. This is not just, a Southern problem. The county was paying for the jailing, but the cities were getting the revenue. And that's part of the reason why sometimes there's a disjunct. Now, in the advocacy community, the Brennan Center for Justice and the Vera Institute for Justice are doing deep financial research to crack this nut. And they're actually looking really deeply into whether these systems make money or don't make money. In New Orleans, Vera found that they were not making money. And so all these people were suffering for no financial benefit. Now, and that's an important argument to make, right? There's the justice argument, which I'm really moved by. But to move policymakers, we do want to also show that this is not making money. Here's my worry and what I really see just as someone who represents people who are impacted by this, as someone who goes into jail and interviews people. The fear and the just anxiety of losing a family member, especially a breadwinner like Shinda Brown, often motivates people to do things that they shouldn't have to do, like sell their cars and not pay their electric bill. And so there is some money coming in. So to a certain degree, there is some money being made from this system. But the cost is huge. You're debilitating people's ability to support themselves and be normal people living with dignity. Even in the driver's license context, the people we interview, the plaintiffs in our case in North Carolina, this is Johnson versus Jessup. If you look at the ACLU website, there are stories of our plaintiffs. They're phenomenal people who are trying so hard without a license to continue working, getting to and from work in a state with really bad public transportation. Also care for their kids. And we have one of the plaintiffs in this case has a child with serious medical needs and needs to go to the doctor and needs to go to bar doctors and is trying to do this without a license. So we have clients who are struggling. They go to work, they come back, they get on another bus, they go pick up their child, they take 2 more buses to try to get somewhere else. They're asking friends and families for rides. They're paying money to Uber that they don't have. And it's really driving them further into poverty. And it's been even acknowledged by such non-sexy organizations like the American Association of Motor Vehicles that suspending licenses for a person who hasn't committed a public safety offense doesn't keep the road safer. What it does is it diverts law enforcement towards all of a sudden arresting people, booking people who are caught for driving on a suspended license when that license was suspended just because they didn't have money. And that's time and attention from law enforcement that they could be spending responding to calls for service and other real public safety problems like traffic accidents. Those are real needs. And so there's a real law enforcement cost there too, but it hasn't been quantified. We don't have a number on it. And so I think your question is really astute.
Hi, I'm Jayne. I'm actually not a student. I'm on staff here, but interested in this issue. How will the recent unanimous Supreme Court decision in Timms versus Indiana that held that the excessive fines clause of the Eighth Amendment applies to states, how will that affect your pending litigation?
Yeah, so great question. We filed an amicus brief in the Timms case that was cited in the majority opinion by Justice Ginsburg. It was a unanimous decision, and she wrote an opinion, and Justice Thomas wrote a dissent, a concurring opinion. But she cited our work. It's not going to impact these cases per se. What the Timms case was about was an individual in Indiana, a man whose car was seized through civil asset forfeiture. after he was convicted of a drug offense. And his argument was, you took my car through civil asset forfeiture, and you shouldn't have, because the maximum penalty I could have been even sentenced to for this drug crime was around $10,000, and my car was worth $40,000. And he actually wasn't a rich person. He had a $40,000 car because his father had recently passed away. Using that inheritance, that was what he bought, and he needed that car for work. And the Supreme Court in the Timms case was looking at this excessive fines argument, and really what it was ruling on was a much more threshold issue. It was, does the excessive fines clause of the U.S. Constitution apply to states, period? They didn't get into what does it mean for a fine to be excessive or not. And that was because in Indiana, the Supreme Court had said, we don't think it applies to the states. We think it only applies to the federal government. This is called a question of incorporation. And the Supreme Court unanimously, all justices held, yes, it applies, like the other parts of the Eighth Amendment, like the cruel and unusual punishment clause. They apply to the states. Now the hard question is, what is excessive? Our case in North Carolina isn't challenging the amount of fines and fees imposed on people. It recognizes that people are often sentenced to pay money they just don't have. And the amounts of fines and fees in the state are exorbitant. They are really high, like the fine that I explained, Shinda Brown's fine of more than $2,400 for 2 traffic tickets. But we're not contesting that. So that decision, while important, isn't going to impact our case. Our case is saying our clients don't challenge the fines and fees at all. What they're saying is, before you indefinitely forever take away my license, please give me a chance to explain that I just can't pay that money and I would like to do something else to pay my debt and get this offense kind of closed out and to move on with my life. That's all they're saying. It's actually much more limited. I think we are actively investigating and pursuing cases that are going to challenge the next phase of the Timms case, which is actually bringing lawsuits saying these fines are constitutionally excessive because based on the nature of the offense and based on the impact that the amount you're contemplating is going to have on this human being, that is an excessive fine. And we need to build the law around that. There's not a lot of law that exists right now. There are some great circuit courts that have held that when you look at something that's constitutionally excessive, you need to take into consideration not just the offense, like was this a speeding ticket versus a bank robbery, but also the circumstances of the person. Because what's excessive for one person is not going to be excessive for another. And there has to be a way to take that into account. Like what's excessive on Donald Trump is going to be different than if it's excessive for Shinda Brown. And that should be reflected in our constitutional protections.
Hi, I'm a 3L. My name is Ashley. Can you talk a little bit about your litigation strategy, especially when it comes to bringing suits in state courts versus in federal courts? Mm-hmm. And related, do you see any nationwide solution instead of bringing lawsuits in local jurisdictions?
Yeah, that's a really good question. So there are some national strategies and there are some state-based strategies, and it depends on the type of case and the precise issue. So the excessive fines clause is a really good example of where we have a national strategy. Like this is an issue that is likely to go back up to the Supreme Court. So we are thinking about what is the right kind of case to go up to the Supreme Court? What are the right facts? What are the kind of facts that are going to help reach a decision of the type that I just articulated, one that holds that when a court looks at the excessiveness as a fine under the Constitution, it's looking both at the nature of the offense and the circumstances of the individual. And we are thinking about what kind of case in a state court or a federal court could wind its way to the Supreme Court to make that rule. In other circumstances, like the Supreme Court already held in Bearden, you can't jail someone because of their poverty alone. You can't do it. It's already the law. So what we're in right now is a state-by-state game of making that law a reality. And what that means is one of the strategies that we're using is finding a really bad actor, figuring out which actor, if sued, could have an impact on the state. Often this means not going after like the tiniest town in like a state, even though they're blatantly violating the law, but going after a town like Biloxi, relatively wealthy. There are other places it could be getting its revenue, second biggest city in the state of Mississippi. If we can show how to do this right in Biloxi, that's going to actually send a message with broader impact than suing a tiny town in the Mississippi Delta that's really struggling with poverty and tax revenue. So we think a lot about like where we bring these lawsuits. And then we think about what's the right way to scale up? Is the right way to scale up by trying to get the Chief Justice to issue guidance to all the judges around the state? Or is the right way to scale up to get the legislature to pass a bill? And sometimes we'll try one way and then we'll pivot to another based on the political circumstances.
Hi, I'm Dan. I'm a 3L. I'm actually a professor at Huckerby's International Human Rights Clinic, and as part of the clinic, we had read the Ferguson report, or at least parts of it, and had started thinking about how you might articulate the types of things that are happening there in terms of international human rights violations. And I was wondering, is international human rights, or at least the language of human rights, a part of the ACLU's strategy regarding this issue?
Yeah, that's a really good question. So we have a human rights project that is a relatively small group, but is similar to kind of a Human Rights Watch. They do really in-depth reporting and documentation and advocacy around what they dive into. And they recently wrote an amazing report on people being jailed and disproportionately punished when they owe civil debts. So debts to credit card companies, debts to, mortgage companies, personal debts, the kind of consumer loans, car loans, things like that. People have literally been jailed for not being able to pay money to credit card companies. When the credit card companies sell the debt, they institute a state court level debt collection action, and they're not served with papers, and people can find themselves jailed too. It's a little rarer, but it definitely happens. And she did this, or Jennifer Turner of the ACLU did this amazing, really deep dive into all the ways in which people are being punished through debtors' prisons and other mechanisms for unpaid civil debts, which we thought was really important to use a human rights frame on. And this is why. When there's an issue like this issue, this actually came up as we were investigating straight-up debtors' prisons when people couldn't pay courts for traffic fines and criminal fines and fees. And we started hearing about this happening in the civil debt context, but we couldn't get a handle on exactly how it was happening. And we wanted someone to bring a really deep human rights documentation approach, which is what the ultimate report did. And the report, you guys should read it. It's called Pound of Flesh. I forget what the subtitle is, but it's A Pound of Flesh. If you Google ACLU A Pound of Flesh, it will talk about 23 states where there are draconian civil debt collection measures. And we found that mechanism, which is very much a human rights tool, really useful there, where the problem was kind of unknown and it wasn't uniform. It wasn't this kind of punishment for inability to pay courts through jailing, through license suspension, through kind of more concrete things, even though the mechanisms in each state are different. And that was useful. The report itself doesn't use so much the language of human rights throughout, although it does talk about how economic, cultural, and social rights are the kinds of rights that are violated by something like this. And of course, as you guys all know, I think most of you are involved in human rights, like studying, probably through the clinic. We haven't ratified the Convention on Economic, Cultural, and Social Rights. So it's hard to really use that as a persuasive advocacy tool when that norm is not a uniform norm in the United States. And we know that, the ICCPR, the International Covenant on Civil and Political Rights, has been ratified but isn't in effect. I forget the precise term. What is the precise term?
I don't know. It's not observed fully.
It's been ratified, but there's a separate thing that Congress is supposed to do to make it actionable. You can't bring an ICCPR claim in a U.S. court. Congress could take the step of saying, yes, I forget what it's called. There's a term, and I'm just forgetting what it is. They could pass a law that says kind of like Section 1983. Section 1983 says anyone can go into court.
Self-executing is a term you're looking at. Self-executing?
Yeah, self-executing. Exactly. It's not
Mm-hmm.
self-executing. Section 1983, Congress said, you know what? People should be able to go into court and sue someone when they're acting under color of state law to violate a constitutional right. That's how we enforce the Constitution. They haven't done that yet for the ICCPR, or they definitely haven't done it for the International Covenant on Economic and Social Rights. So it makes it tougher to bridge that link. So we've had a number of internal strategy conversations about how much should our Human Rights Project focus on this area of work. And right now they're focusing more on juvenile life without parole and long-term confinement, in part because the international human rights norms are more solid and they're more easily kind of brought to be fruitful on that issue than this issue. Doesn't mean that this won't happen in the future. It doesn't mean that that door is closed. I think, but we have to make kind of judgment calls about like how we're going to use our resources, our limited, really, really valuable human rights project resources on which issues. And this was not the issue we thought was the best issue to use it on right now.
I would add to that the ACLU has been instrumental in thinking beyond the human rights litigation context, right? Because you may not be able to sue directly on these particular human rights treaties, but they are legally enforceable at the international level. And so the ACLU has led very important reporting to the Human Rights Committee, the body that oversees implementation of the ICCPR, also the Third Committee, which oversees implementation of the International Convention on the Elimination of all forms of racial discrimination, because there are extremely strong norms around the prohibition on racial inequality.
There are.
For example, right? So
Yeah,
even, when I heard you telling the stories and talking, I was so struck by the intersectionality. I mean, I was struck by the ESCR violations, but I was really overwhelmingly struck by this as a story of racial inequality, intersecting with gender inequality, intersecting, with a whole bunch of different features that are very much bedrock principles of international human rights law. And I know the ACLU has been really key in sort of mapping that path forward, particularly the UN.
Yeah. And it's interesting, like, I know the recent CERD reporting included a lot on Ferguson.
Yeah, exactly.
And I think relied a lot on, like, the DOJ report. Yeah. We haven't built as much on this body of work into it. And part of it's just the timing. Like, it's, if that reporting was happening right now, we might do more with it. Yeah. But it's a good question.
Could you talk a little bit about some of the non-litigation strategies in this area that the ACLU is pursuing, like advocacy and political pressure?
Yeah, those are huge. So that's really gets to the question of the scalability. So when we're trying to figure out, I'll give you a concrete example. So the ABA 10 guidelines on court fines and fees was a 1-year campaign by the ACLU to get that product out of the American Bar Association. And the reason why we invested so much in it, and this might sound weird that the ABA was like a target of the ACLU, but they were in like a friendly way. In 2010 when we started doing this work, we were really puzzled by why is there a Supreme Court decision that is so clear, yet the reality on the ground is just not matching it at all. That is a failure of norm building. You have the law, you don't have the norm. It is normal for Shinda Brown to go to court and not have a lawyer when the judge is like imposing money on her she can't pay, knowing that the penalty could be jail. It was normal for the judge not to assess her ability to pay. It was normal for the jailers to say, oh, well, of course you're going to stay here for 57 days without seeing a lawyer or talking to a judge when you can't pay this money. How do we change that norm? And we actually looked at the country and we were like, who are the norm setters here? Who can be our allies in changing the culture of courts and jails? And we chose the ABA because the ABA, the American Bar Association, is the country's largest group of lawyers. It includes prosecutors, judges, defense attorneys, pro bono, private practitioners, law professors. And when the ABA issues a resolution, it has the imprimatur of the entire ABA, and it goes through a 450-person House of Delegates. It's kind of like Congress and kind of less dysfunctional, but definitely as chaotic. And there are multiple interest groups that you have to kind of lobby and court and involve in the process to get their buy-in. It is really elaborate. So we thought at first, when I thought personally in it must have been 2016, I was like, oh, we can just like call up our allies at the ABA and they're going to want to do something about this problem. It's so terrible. Turns out they did think the problem was terrible, but they were like, we're not even sure what to do about it. And so we basically lobbied them to create a work group. They created the work group, in part motivated by Ferguson, because they were like, we are the American Bar Association. The distrust in law enforcement revealed to the country based on the Ferguson report and the killing of Mike Brown is a problem, and it should be a problem for us because we are lawyers who believe in the rule of law. And if the rule of law isn't working, we need to do something to rebuild that trust. So they created a work group, and then we made the case to the work group and the ABA president that, listen, if you want to rebuild trust in America, the ABA needs to do something really powerful to enable the ABA to push back against courts as revenue generators, because that is part of what is driving the policing and what is driving the distrust and is leading to a two-tiered criminal justice system where people of color are treated differently than white people. And they totally agreed. And the work group then was the kind of brain trust that we used. We did the principal drafting of the ABA 10 principles. We did the research. We put in the sweat equity. We then lobbied different people to work with the work group to get their buy-in, and then we worked with people on the work group to get other parts of the ABA, like the judges and the prosecutors, to agree to this. And they did. But it was a year-long policy advocacy campaign that resulted in the ABA 10 guidelines. And we do similar stuff when we're trying to get, like, court rule change in Mississippi. We filed the Biloxi lawsuit. The MacArthur Justice Center, who are our allies and colleagues, filed a similar lawsuit against the city of Jackson, Mississippi. And then we knew that those two lawsuits got the attention of every state official in the state of Mississippi, every court official, the attorney general, the governor, the chief justice, other justices on the Supreme Court. But what were they going to do about it? And so then we knew at the same time that there was a system for court rule change. And we worked behind the scenes together to lobby for the same rule changes. So now the rules, Rule 26.6D, now says a court has to consider ability to pay before they jail someone. And it's an addition. You shouldn't have to do that because the Supreme Court already said it, but it helps. And so we think about who's the target. How do we influence the Supreme Court Rules Committee? Who are the most influential people? Is it a public process? Is it a private process? Is it behind the scenes, or are we doing something in the press? And then we come up with a strategy. That was a very behind-the-scenes strategy. Like, no one would know after seeing that Supreme Court rule come out that the ACLU was behind it. Same with the ABA. No one knew that we drafted and moved the whole thing. And we don't want them to know that. We want the ABA to get the credit for that because we wanted to have the imprimatur of the ABA, the nation's largest association of lawyers representing judges and prosecutors and criminal defense attorneys across the country.
More questions? I have a question around the 2010 report that you mentioned, and particularly thinking through in your answer to Dan about more generally the role of documentation in sort of these types of advocacy and litigation campaigns. So what prompted the 2010 report? Like, what had sort of gotten you to a point where you felt as an organization that you wanted to be building layers of reporting, litigation?
That's such a good question. And so I can't give the full answer because one of the masterminds of that report, and this shows you a lot of this is about people and politics and time, Vanita Gupta, who spearheaded the Ferguson investigation as the head of the DOJ Office of Civil Rights, was the lead attorney working on the ACLU's report In for a Penny in 2010. So it kind of shows you how, and this is what I mean about people. Like, she worked on this issue at the ACLU. She helped blow the cover on this issue. And then at the tail end of the Obama administration, when the Obama Justice Department wanted to be more proactive, like, they actually weren't doing that much that was that great on criminal justice before the last 2 years of that administration. And when she was appointed and she had a mandate to do something important on race and criminal justice, she did it. And she worked on policing litigation. DOJ did really excellent work investigating police departments that were racially profiling and entering into consent decrees. And she did this. She brought Justice Department resources to this issue by investigating and doing that report. In terms of, like, I will say, like, on other issues, we have this conversation a lot. Like, when do we do a report? One instance is when we're not sure that litigation could work because the problem is just too diffuse and we really need to get a handle on the problem. I will say we do get pushback because reports are expensive.
And they're time consuming.
They're time consuming, and if they're not properly structured at a specific target with a specific ask, they can totally fail. I've seen a ton of reports that have not had a tangible policy result. In for a Penny was not that report. In for a Penny was a highly effective report. It is still cited today. in briefs in courts, in policy conversations about the problem and solutions. That report was seminal. That report and a report by the Brennan Center, both in 2010, kind of blew the lid. And I think that what actually led to it was, I remember when I was at the beginning of my career in 2008, 2009 at the ACLU, and a senior staff attorney, Robin Dahlberg in Michigan, was hearing about people being jailed because they couldn't pay. And Michigan was one of the key states centered in the report. And there were some stories coming out that were just crazy, like a young man who was jailed because he couldn't pay a fine for catching the wrong fish out of season, like that kind of thing. And I remember we were in a staff meeting and we were talking about it. We were like, this is weird. And if you go back to 2008, it was a financial crisis. And I think people were trying to get their heads wrapped around things were already bad. What is the financial crisis doing to make this even worse? I will say, like, we have actually recently hired someone whose job is to make sure that our reports from inception to execution are thought out to be in line with our strategy, rigorous, and targeted towards a policy objective that makes sense and is achievable. Because we've seen too many reports that are really good and interesting, but they don't end up having the impact and the lasting utility that we want them to have. I would say, like, our Human Rights Project, though, is excellent. Their reports are uniformly excellent. And I think that rigor that they bring from a human rights frame is part of what makes them so good. In the debtors' prisons context, a lot of our affiliates, state affiliates, have done, like, quick and dirty reports on this issue, and they're still really effective. So there's a way to do it without making it this 2-year-long deep dive. But it's definitely more of an art than a science.
Can you talk just a little bit as well about how the national ACLU and that strategy on this issue like interacts with the affiliates and because I know it's a complicated.
Yeah, actually, we work really closely with our affiliates. So on debtors' prisons issues, we always work with our state affiliates especially because it's not just about airlifting down and winning one lawsuit. It's really about changing systemic cultures in addition to changing and improving the law. Like our 3 goals are enforce Bearden, establish the right to counsel, and change the norms in courts, change the culture of the courts. And they can be done in lots of different ways, like these sorts of guidelines, these sorts of kind of top-down within the state rules that are coming from within the state. And so who's going to have the intelligence about the Chief Justice? Who's going to know the legal community and the policy community of their state? Our affiliates. Our affiliates are amazing. They are amazing resources. And we are the only organization in the country that has that kind of local knowledge of policy and practice and people, the targets that we want to move on this issue. So in North Carolina, our driver's license suspension case is brought by a coalition, the National ACLU, the Southern Poverty Law Center, the ACLU of North Carolina, the Southern Center for Social Justice, and we each have a role to play. We're bringing kind of national expertise in terms of the legal strategy, understanding this case law in a really deep way. Our affiliate, they know how the court system works in North Carolina, because North Carolina's court system is different than Mississippi's, is different than South Carolina's, is different than Georgia's. And our affiliate in North Carolina, our attorneys in that affiliate are just supreme experts in understanding state court litigation, state court strategy, how to find effective plaintiffs, how to manage those plaintiffs, how to reach out to them and keep them abreast of what's happening. And that is integral, because these lawsuits should never just be about using people as pawns in a broader game. It should really be about giving them a voice from within the lawsuit to achieve what is good for them. And they are very much a part of this, and our affiliates are critical to that. I would not want to counsel a case like this without a partner on the ground, really close in physical proximity to the people that we're representing. And that's part of what our affiliates do so well.
And that's actually a perfect note on which to end. Please join me in thanking Ms. Choudhury for that extraordinary presentation.